Hello, everyone, and welcome to another Duquesne Kline Law Library Legal Talk series. I'm Neacsu. I'm the director of the library, and it is my pleasure to have this talk series today with Jane Campbell Moriarty, the Carol Loss Mansman Chair in Faculty Scholarship and Professor of Law at the Thomas R. Kline School of Law of Duquesne University. Jane teaches evidence, professional responsibility, and expert evidence. She has also taught law and neuroscience, remedies, employment, and disability discrimination, as well as other courses. Her scholarship focuses on scientific evidence, neuroscience and law, and professional responsibility. Professor Moriarty has also written articles about behavioral and forensic science evidence, the Salem witchcraft trials, and violence against women. In the last few years, much of her work has involved the burgeoning field of neuroscience and law. Professor Moriarty is a frequent speaker on scientific evidence, neuroscience and law, and legal and judicial ethics. She served as president of the evidence section of the Association of American Law Schools. And I'm going to continue, Jane.
Oh, no,
this is not enough. Professor
wonderful.
Moriarty has twice received the Dr. John E. and Liz Murray Award for Exemplary Faculty Scholarship in 2016 and 2022. During her career, she was named Professor of the Year at Akron Law and awarded the Excellence in Teaching Award at Duquesne Kline. A contributor to Black's Law Dictionary, Professor Moriarty has been included in Who's Who in America and has received awards for her scholarship. She was a visiting professor at Case Western University School of Law, as well as the University of Pittsburgh School of Law, and a distinguished visitor at Stetson Law School. Just to add, Professor Moriarty received a BA from Boston College, summa cum laude, where she was awarded a Babst Philosophy Medal and elected to Phi Beta Kappa. And she graduated cum laude from Boston College Law School, where she served as a law clerk to the Superior Court of Massachusetts and to Ralph J. Cappy, Justice of the Supreme Court of Pennsylvania. In 2021, she received her MA in Healthcare Ethics from Duquesne University. And in 2010, she attended Neuroscience Bootcamp at the University of Pennsylvania Center for Neuroscience and Society. It is truly my pleasure, Jane, to have this conversation with you. So please, let's start with our first question. How would you like to introduce yourself?
Well, thank you, Donna. I would call you actually Dr. Neacsu, which seems to be appropriate, but I would like to be called Jane, and if you don't mind, I'll call you Donna during this interview. That works well for me.
Thank you. So would you like to add anything else, or shall we go on?
No, let's go on. I'm happy to start with the questions. This was fascinating to put this together to prepare for this. It's so infrequent one has an opportunity to talk about something that's been a driving force in life for me since probably 1990, which is, scholarly discussion of the law. It's the lifeblood for many of us. So this is a thrill to be here, and I'm really excited to talk about it. So thank you for
if I may. If I may, I would like to tell our audience about one more thing that wasn't there. The death of eyewitness testimony and the rise of machine evidence. This is an amazing conference that you put together. And your scholarship and your generosity, your intellectual generosity, and the welcoming. And I have to acknowledge that you trusted me as a newbie here at Duquesne to put me among these amazing speakers and the representatives in each one's area of scholarship. And this happened only in April 8th, 2022. And to disclose more about us, I'm also in Women in the Law, one of your books from 2005.
Long before I knew you, I put you in Women in the Law. Which, by the way, I want you to know you're in excellent company. My dear friend, I call her my dear friend because I spoke to her for 30 minutes on the phone once. Elizabeth Warren wrote an article that we published in there, and she was quite gracious and lovely. And this was when she was only a professor at Harvard and was still a rock star. And by the way, wrote one of the best articles I've ever read called Women, Bankruptcy. I think something about women in bankruptcy. It's a brilliant article. And I know very little about bankruptcy, but I learned a boatload reading that article. And boy, is she a terrific writer.
I know. Catherine McKinnon is there. And
Yes.
Even the dean from Columbia, Gillian Lester. So you have everyone.
Everyone's in there. Right.
So let's go on. What inspires you to write, Jane, please?
So I always say we write about what, for me, I think writers are artists. Much the way artists work out a problem over and over and over in on a different canvas, with different media, with different modalities, at different periods in their life. I often think they're working on the same problem. I think that's true for many of us who write. I think I wanted to be a writer more than I wanted to be a lawyer, but I knew I couldn't make a living. And so when I write about a handful of things. The first is, how do we get to ground truth? I'm always troubled by knowing the facts, as I say. I want to know what ground truth is, because I don't think we can make informed decisions in the world without knowing ground truth. And I want to know why the plural of anecdote is not data. In other words, how do we test lots of opinions that, about a subject or stories about a subject, so that we know what's real and what's signal and what's noise, as we would say. And I have one overarching question, and maybe this is a bad way to spend one's life, but it's my life, and this is how I spent it. How do we know when we're wrong? I think it's a profoundly troubling question that we need to ask ourselves a lot. And we don't ask it a lot because we are humans and we are bias laden and we are subject to confirmation bias and seeking out information that confirms what we think. So how do we know when we're wrong? And I think in the law, this is critically important, which is we need to know when we're getting it right and when we're not. And people's lives depend on this in every trial. I started with the Salem witchcraft trials, and I have plenty to say about how we were wrong then and how we are still wrong doing many of the same things. In fact, I'm speaking on a podcast next week about the Salem witchcraft trials and evidence. And, the parallels are striking to how we developed evidence then as we do now, because we're humans. Doesn't mean it's bad. It just means we have to really think deeply. So I always like to say that I write like the Star Trek creation Voyager, which was the first Star Trek movie, if you go way back in time. So Voyager was sent out into the universe to collect knowledge. And that's who I am. I'm Voyager. I'm always looking to learn things I know nothing about, which is why my work in law sort of took me to science and behavioral science. It's multidisciplinary. My work actually spans law, history, philosophy, cognitive science, neuroscience, behavioral science, and then also problems such as the dangers of making inferential leaps of thought. And that inspires much of my work. I have often written, about the inferential leap from data to opinion, and how how complicated causation is and how correlation isn't causation. And how do we know we're not giving into all those biases in the law? So if, even though my work, some could say my work doesn't have focus because it's across so many disciplines, but there is what I call a unified field theory. And that is, how do we get to the truth? How do we know when we're wrong? So I've spent 40 years writing about that.
May I thank you for being interdisciplinary? In a way, I think you are a trendsetter, Jane, because right now, if a legal scholar is not interdisciplinary, I think it limits very much the impact of that scholarship. So rather than say that the people were not happy, maybe you were ahead of your time and actually you set a trend and you open avenues for other faculty members.
You know, there's a real danger of writing across lines, as Marianne Glendon, the great Marianne Glendon, says. She thinks it's a terrific idea. She's been pushing for it for generations. She was a law school professor of mine. And I admire her greatly. But, you know, the danger is, you know, your reach can exceed your grasp and you can make terrible, terrible errors. And I fear that, right? Because I'm always worried about how do we know when we're wrong. And one of the things I've done is I take very deep dives into the work. I am not a surfacey writer. I tend to go down rabbit holes and learn everything I can about an area. And it slows my work down. I think I would have been more productive. I know this looks like productiveness, but I have like 18 articles I've written, I think. But I haven't finished a lot of things because I care too much about trying to get it right. And sometimes I put things on a shelf and they become zombie articles, as I call them, waiting for me to bring them back to life. So
I hope you're going to bring them back to life because you are a remarkable scholar.
Thank you so much.
And I do believe that interdisciplinarity is the key in order to find solutions, especially such philosophical solutions like you are seeking.
Well, thank you.
So we are going with, who are your favorite legal writers?
So, you know, it's really easy to try to pick favorite authors who write novels, for example, or even people who write true, you know, who don't write law. But legal authors are hard because I always tend toward the poetic, and not everyone does. So for that reason, I love Justice Cardozo. I'm a big fan of his Meinhard versus Salmon, not honesty alone, but a punctilio of an honor the most sensitive. And he had a way with words that most lawyers do not have. But there's a number of legal writers I adore for different reasons. One of whom is the Honorable William Young, former Chief Justice of the Massachusetts District Court, who's a phenomenal writer. And I also clerked for him. When he was on the Superior Court, I spent several months working for him. And his writing inspires me to this day. It is clear, it is forceful, it is powerful, and he tries very hard, as he would say, to get it right. The reason I do evidence law is Bill Young, and I cannot think of a more honorable person to have learned from. I love Justice Sotomayor. I love Justice Stevens' work, and I love Justice Stevens because he disappears into the work. You don't see his fingerprints. You see the clarity of thought. You see the process, which I like. Justice Breyer, for his work in scientific evidence, he's wonderful at it. And he too is I am a New Englander. He is he's an old New Englander, and he writes like one. And I love that about his writing. It's historical in a way that is very grounded in the history of Massachusetts. And if you're from Massachusetts, you would know what that means. I very much admire the quality of Justice Kagan's work as well. Now, as law reviewer, book writers, I really like, as I've said before, Elizabeth Warren, who I think is a powerhouse of a writer and a thinker, and has really good clarity and deep grasp of facts. David Fagman is one of my favorite writers in the area of scientific evidence, probably somebody I've followed for many, many years. He's a friend of mine. He's now the chancellor and dean at UC San Francisco. His work is really profoundly important and has been. And also Jennifer Mnookin, who is also now a chancellor of the University of Wisconsin, and is a former law professor who writes in the area of scientific evidence. They are both incredibly important in my field, incredibly nice, decent people who've really added an amazing amount to the area. And finally, Chris Lebogan at Vanderbilt, who writes across multiple disciplines and does it better than almost anybody, does it more accurately and more impressively than anyone I know. And I know Wes Oliver feels the same about his work in criminal procedure. I just think, I have as I say, I have an academic crush on Chris Lebogan's work because I aspire toward it. I will never reach it, but I'm so impressed by it. And finally, I just wanted to add this in because this is one of my favorite books. It's hard, it's like picking favorite children, but I don't know if this is backwards or not, but Arthur Schlesinger Jr., who is a legal historian, a really well-known legal historian who died in 2007, wrote the most wonderful book on politics here called his Journals. And from 1952 to 2000, he chronicled everything that happened every day in his life, and he was intimately involved in politics. It is such a wonderful view of the history of the period, and he writes like a dream. So those are some of my favorite writers, legal writers. I include Schlesinger just because I don't know how you separate politics and law, really.
It's such a pleasure to listen to you. So I'm proud of myself for having given myself some questions, because otherwise I would just say, Jane, please take it from here and go on.
And cut me off if I'm going too long.
No. It's so important for our Duquesne student, Kline law students to know their faculty, and the ability of having this type of conversation where you can explain what it takes to reach your level of achievement. I think it's really crucial for someone who starts their legal profession right now. So I thank you for your service, Jane. And I'm moving on with the fourth question. What piece of your scholarship, and I have to let everyone know these are just a few of the books that have the name.
You asked me to get some, so here's a few more of the things I've written, or chapters I've written, or books I've edited. I love editing. Editing is a great way to learn to be a better writer.
That is true, yes. So out of this body of scholarship, what piece would you like to talk about today? And please talk about more than one.
Okay, so I'm working on a book, and I think people are at this point rolling their eyes when I mention it, because I've been working on it for several years. And the problem is things get in the way and I write other things. I have about 80, 90 pages written of the book. And my plan is, starting in March, is to start rewriting the book and finish it, just without other things. So I want to talk about the book because it is the one goal I have not achieved that I feel bad about because I've not finished it. And it's called Are You Lying Now? Neurotechnology and Law. And I have a contract with NYU Press, who's been very patient with me. And it is the history of lie detection in law. It looks at the past, it looks at the present, it looks at the future. And one of the things that I think people don't understand is that lying, it's a lot about lying. It's a lot about lying. So lying is genetically programmed into us. It's a skill we learn in childhood for as part of development. And it's one we use all the time to get resources, to get food, to get mates, to get, it's ever present. And if you don't believe it, watch children, right? They learn at a certain age how to lie, and it can be beneficial. In other words, if you've ever been on an internet dating site, and there's actually studies on this showing how much do people lie, when do they lie, what do they lie about, And by the way, we lie to the people we love. That's who we tell the whoppers to. We tell lots of little lies throughout the day, according to research psychologists. Bella DePaulo is probably one of the leading researchers on the area. And that was all fascinating to learn. The other big thing that I think is great that we don't realize, and again, this goes to my whole how do we know when we're wrong thesis. We are really good at self-deception. We convince ourselves. By the way, it takes a lot of self-deception to go out in the world and say, I'm good enough, I'm strong enough, and darn it, people like me, right? There's a lot of self-deception that goes into that. And so one of the things I'm looking at is this history of both lying and lie detection, because we hate being lied to. It produces a rage response in humans. And we really would like a really good lie detector. And that goes back 1,000 years. This is not a new development, except if it's used on us. And then, of course, we don't feel very comfortable, which explains why the law doesn't like polygraph evidence. I mean, they say it's not reliable, but that's not the real reason. The real reason is we don't want anybody polygraphing us if we don't have to. And so how do we put together this desire to know when people are telling the truth, lie detection, our innate disdain for lie detection, and the history of law? And that's what I'm doing. So no one has written this book. It's multidisciplinary, it's historical, it's contemporary, it's forward-looking. It combines neuroscience, law, behavioral science, legal history, evidence, statistics, and stories about people. There's a lot of narrative about different people. It's got polygraph, it's got MRI, it's got developing AI technology. And at the end of the day, I think we can look back at the Inquisition, we can look back at the European witchcraft trials in which probably 50,000 people were burned at the stake, and many others tortured. The Salem witchcraft trials, where almost 200 people were accused of witchcraft, and about 19 were hanged for it. We can look at a lot of trials where people were imprisoned for things we no longer even believe. Some of the daycare child sexual abuse cases where 20, 30 children claimed to be abused, we now no longer think they happened. And we would think, gee, wouldn't it be great if we could get to the truth? But I'm not sure trial by machine is what we want. I think there is an essential humanness to trials that I'm afraid we will lose in perfecting the machine-driven lie detection. I think we see this already in trials where we're using a ton of machine evidence. And we are humans, after all. We are not machines. And we have to think about carefully the role they're taking up in our courtrooms, and also in the sort of moral play that is a trial. A trial is more than just getting to the truth. It's a reconstruction of truth, right? It's a reconstruction of memory, of data, of facts, of documents, and also of moral judgment by a jury of our peers. And I think that's critically important. Bill Young, for whom I worked, who I said was my favorite writer, used to say all the time, democracy trials are day-to-day democracy. The jury is day-to-day democracy, and he's absolutely right. And we've taken juries away from people with all the plea bargaining we do and all the settlement. And I think it's essential for our democracy and our humanness that we have real trials with real juries. And so I think where I'm coming to in this book I'm writing is there's a lesson history tells us, and the one is to be very careful about these methods of lie detection. And by the way, they thought at the time of the Salem witchcraft trials, they were doing this scientifically. The people running the trials were men of science. Increase Mather and his father and his son, Cotton Mather. And yet science now is not science then. And my guess is in the future, science in the future will not be science now. So there's a lot of caution to be had, I think, here. So that's the book I'm writing. And then I'm also writing multiple articles and a chapter that I'm hoping to finish this winter. The first of which is I'm writing something called off-label neuroimaging. And it's about how courts use neuroimaging for pieces of work, for purposes for which they're not recognized. So that's one piece, and there's my dog who helps. He's my writing assistant.
So now we are getting to see your writing assistant, Jane.
Yeah, and my teaching assistant. He's very good at both, actually. He's better as a teaching assistant, I'll say. He tends to put his head on the books, but the second piece I'm writing is a piece I spoke on at a conference last week called Hysteria Redux, and that's gaslighting in the age of COVID. And as a science writer, and now as somebody who has a healthcare ethics master's, I've been writing a lot about COVID, science, and some issues about gender, which I'm finishing an article for that. I have a co-authored peer review, under final peer review, article on forensic science with a colleague from Berkeley and another colleague from Indiana. And that's going to, hopefully will get peer reviewed, and it will be in the 3rd edition of the Scientific Evidence Manual for Federal Judges. And it's a very long chapter, 500 footnotes. We've been working on it for a year and a half. And so that's coming out. And then finally, I'm going to have a short chapter, possibly with one of my co-authors who I've written about neuroscience lie detection with, on neuroscience lie detection and mind reading. And is that what we're doing, or are we doing something else? And also the importance of the privacy of one's mind when we engage in these. And finally, I've just finished several chapters for my treatise right here that I've been working on for several years for scientific evidence. I'm a co-author of Scientific Evidence with 3 other colleagues, including the amazing Ed Winklereid and Paul Gianelli, to whom I'm very grateful for inviting me to join them on this. And I write several chapters of this book. And so every year I update those chapters. And that's what I'm working on now.
What can I say? I'm speechless, Jane. I should ask you, do you sleep at night, or you just study and write?
You know, I look at people like Chris Slobogan, and I wonder that same thing, because I often feel like a piper, as my grandmother would say, somebody who's kind of lazy, that I don't work as hard as I should. And I do think we all work differently. For example, my husband is very linear, and I always say I'm very circular. I get there eventually, but I have to go off and do different things and come back to them. So sometimes my work takes longer than I wish, but I don't want to let go of it until I'm really happy with it.
I think that's commendable, because
remember, I'm just old. That's how I did all this. I started, in my 30s writing, and I'm 30 years older than that now. So this is the work of a lifetime, not of a week.
This is marvelous. I believe that you said that you started writing before you became an attorney, and there is a book there. Would you like to point that to us?
So I wrote this book, this treatise. It's 2 volumes, Psychological and Scientific Evidence in Criminal Trials. And I had done a book proposal in 1993, and I had wanted it to be about just psychological evidence, like syndrome evidence, profiles, insanity, competency. And that is one whole volume. But I ended up writing 1,200 pages at the request of and it was working. By the way, I was a lawyer, and I was much younger. I must have had more energy. And I wrote 2 volumes because the Daubert case had just come down that year, and they wanted me to write about scientific evidence, which at the time I knew very little about. So I said yes, because I didn't know better. If I knew what I knew now, I would have said, no, I can't do that. But I said yes, and I wrote it, and I wrote 1,200 pages, and it was published in 1995. I think it came out in 96. And that was before I became a law professor. I just liked to write. And it was something I wanted to do. And I wrote the book in 18 months. I was working about 30 hours a week and writing the rest of the time. I went on kind of reduced hours to write. And then I became a law school professor after that. But it wasn't easy, because nobody writes a treatise first. Everybody starts with a short article. I didn't do that. I wrote an article in law school on desegregation. And then I never wrote another. I guess I wrote a couple of small pieces with Justice Cappy and one by myself, actually, that mentioned Ken Gormley in it. but tiny little pieces, not in law review articles. So I went right from lawyering to treatise writing, and I updated that for 10 years, and then I had to stop because I had to try to get tenure, and I had to write more articles.
Just a follow-up question, because it's very interesting. So when you were a law student, you were interested in civil rights and desegregation, and I suspect legal history. And then your first piece of writing is on science, the intersection between science and law. Can you explain that arc, because it's so unique?
Well, you know, I didn't want to write for the regular law review because I thought I'd have to write something that was really dry and dusty. And I wanted to write about what I wanted to write about. And I really cared a lot about civil rights. I still do. And remember, this is like 1980. This was like right when the court started really shifting in every possible direction, right? This was a big sea change in the court. 1980 when Reagan was elected. And I'm in law school, and I care very much about civil rights. And I actually was writing more philosophically at the time. I had been a philosophy major. I was torn between getting a doctorate in philosophy and going to law school. And then I realized I probably wasn't made for being a philosopher, which was a good decision. I wasn't. So I was writing about what I called the irreducible rights of humans and what we all agreed on. And I was putting it in actually some science, which is Thomas Kuhn's theory of the scientific revolution, in which he talked about sort of paradigms and thesis, antithesis, synthesis, and how you have these paradigm shifts. And so I was using some Hegel, I was using some Thomas Kuhn, I was using philosophy, I was using scientific theory, and it all made sense to me. And I was citing Larry Tribe, Trial by Mathematics, in there. I still love Larry Tribe's work. I should have included him. I read his entire con law treatise in law school in about a weekend, and I just fell in love with the work. So he's right up there in my favorite writers too. And anyway, and so all of these things kind of percolated in with me, which is, what is ground truth? What do we all agree on that is right? And so that's what I was writing about. I'm not sure I was writing about busing and desegregation. I think I was trying to get to this deeper issue of ground truth. So that's how I did that. Then I was a law, then I practiced law, then I became a law clerk for Justice Cappy. And we had a lot of cases that came to the Supreme Court of Pennsylvania on syndrome evidence, on insanity, on competency. And I thought, wow, what a mess everything is. I want to clear this all up, because, you know, I knew so much at that age. It's amazing how much I don't know now, and I thought I knew when I was young. And so I wanted to write about these things because they interested me. And so I did a book proposal, and I got a contract, and I wrote, and there was a book.
I just want to make clear to you that, in fact, you haven't betrayed your philosophical roots, because searching for the truth is epistemology at its best, and you're still dealing and writing about it. So,
and the other side of that coin, Donna, is, how do we know when we're wrong? Right? Because I don't think you can know when you're right until you know when you're wrong. I think how we know when we're wrong is a profound, troubling question that we don't ask enough.
that is the flip side of the same coin. So you are a philosopher. I'm afraid that you don't want to hear the truth.
I take that. I'm honored by that coming from someone who is a real philosopher, and I appreciate that. And by the way, I loved having your philosophical work in our conference and in the law review symposium we wrote. I thought it added an incredible amount of richness and structure to the conference that was really critical. So
I'm grateful to you. That was possible because of you and your generosity of spirit. So thank you.
No worries. It was my pleasure indeed. So
we're moving along. And we talked about the pieces of your scholarship that you are currently working on. And I'm going for something deeper now with the fifth question. What are the main ideas behind it? You already have explained some to us, but because this is deep, would you like to unpack some of them for the benefit of our young students listening to us?
So I think in scholarship, to do good scholarship, people have different approaches to this. Some say you should be a hedgehog. Some say you should be a fox. And a hedgehog is somebody who drills down into a single area and spends their whole life writing about it. For example, John Murray on contracts is a beautiful example of that skill. A fox is someone who hops from subject to subject. I think of Wes Oliver, for example, as more of a fox. You're more of a fox. I think I'm going to call myself a foxy hedgehog. I have a couple of main areas, and you may be one too. I have a couple of main areas I write in, but then I sort of turn the lens and I learn something new that gives me a different way to look at it. So, for example, I've always written about science because I think science is to quote Carl Sagan, a candle in the dark. I think our best decisions are guided by scientific method. I think we actually learn a lot about the world. Our technology, our scientific discoveries, they certainly don't address the moral issues that we need to be addressing. But my God, the things that humans have figured out. We have something floating around the galaxies and taking pictures. Like, you can't. There's a big anti-science movement, and Peter Hotez is writing about this: the dangerous rise of anti-science and anti-Semitic thinking. I mean, I think they tend to go together. That I think is really dangerous. So I think the role of science in law is critically important. I also think the role of getting science right in the courtroom is really important. And it comes in all the time. And we have to think, are we doing it well? Are we doing it correctly? Are we convicting people on more than anecdote? Because we do a lot of that. And so those are the kind of deep pieces in my work. I am an evidence scholar. I am not a scientist. I do not have an advanced degree in science. I don't hold myself out as one. But I think science, in all its manifestations, behavioral science, cognitive science, neuroscience, scientific method, they inform the legal process, not only in the courtroom, but outside of the courtroom. And so I think it's really important that we get it right. And I care more about urging caution than I do about let's get everything into the courtroom. From my very first article, I have written about the importance of proceeding cautiously lest we get it wrong. And I think this is where humility, which is one of my favorite concepts, comes to play. Eliot, who's my favorite poet, despite many troubling aspects of his writings and his personality and his comments, says wisdom, the only wisdom we can hope to acquire is the wisdom of humility. Humility is endless. And that's a good lesson to remember both in science, law, and in writing, is these are deep themes to my work. So
I cannot emphasize sufficiently how important your perspective is, especially given the current Supreme Court membership, if you want, the justices who seem to be very uncomfortable with science and very uncomfortable with humility. And I think it's the worst combination to have when you are one of the nine most important people in the legal system of our democracy, to be uncomfortable with science and not to be humbled by your ignorance and your discomfort with science. So you're a national treasure, Jane.
Many people, I think one of the things I see a lot of, I think, in the Supreme Court in part is they're not engaging in reflection about self-deception, which is, one of the really big problems of humans. They're no different. They're just like the rest of us. The other problem is they tend to, like the rest of us, live in an echo chamber where they hear only confirming voices in large part. If they come into an argument with their mind made up They're just going to engage in confirmation bias. And when you have very strong views, and I am a person with very strong views, so I have to admit to this flaw in a very big way in myself, that you go looking for what you want. And, it's people like Justice Stevens who really didn't. Justice Stevens really would always do this wonderful examination of what was in front of him and try to find the process way through that seemed to clarify what was the right way to go. And I have a lot of admiration for that. I think we have I think Scalia is a really good example of somebody with very strong views. Like, he could not be shaken from his views. But he also was able, in my opinion, particularly in a bunch of evidence cases, to come out in a direction he disdained. He just hated, because he thought, this isn't right. Like, here's, for example, his confrontation clause work, and he writes in Michigan versus Bryant, writes a scathing dissent. And he doesn't like the outcome. He hates the outcome he's coming to, but he's convinced he has to do it. The question is, though, again, how do we know when we're right? How do we know when we're wrong? I think science is a candle in the dark. And I think approaching it with some degree of humility, which is, what are the confounding factors? What don't we know? Where's the causation? Where's the correlation? How do we tear these apart? I think those are the things that we should be asking, judges should be asking. And they write conclusively about science they really don't understand sometimes. And and we are where we are with it. So
thank you. Please continue your work. It's so important at the national level, and for everyone practicing law, or a student of the law, or a member of the academe. So moving along to question 6, what does it add to the existing body of literature in this field? And I know that we've touched upon, but if you would like to summarize somehow.
So I think my book, first of all, nobody's written this book. People have written about the history of lie detection. People have written about polygraph. People have written about neuroscience lie detection. And people have written about the witchcraft trials, the European witchcraft trials, about the Inquisition. But I think drawing a thread through all of this is a unified field theory, that there's something going on in humans that has been going on for a long time with very bad consequences for many people, is a really important theme that we need to unpack. And we need to see the historical sort of pull of history and how it gets us here. And then think about going forward. What do we want? What do we not want? Do we really want a perfect lie detector? What does that do to us? What does that do to trials? What does it do to our humanity? If, I hypothesize that lying, that having a key to knowing when people are really lying is probably the ultimate, like, genetic key, right? If you knew when everybody was lying, you'd know everything, right? When is somebody bluffing? For example, when is Iran telling us the truth about nuclear weapons? When is a presidential candidate lying to us? Some are easier to tell than others. But those would be really critical factors. If we knew the truth all the time, would this be a better world or not? And how would it change us as humans? And I think it's something we really have to talk about and think about, because we are on the edge of developing technologies that will be able to pretty much conclusively tell us, I think, if we're telling the truth or not. I'm not so sure, fMRI lie detection isn't, I think it's a very big step, but it's cumbersome. And that's the reason I think it won't ultimately work. It's too big, it's too hard, it's too expensive, it's too complicated. But what if we make something simpler, which my guess is we are on the way to doing? Then what? How will we feel when an authoritarian government gets a hold of it and we can't keep our thoughts private? And you'll be tried for what you're thinking, and not even expressing, but just thinking. And that's a step too far. And how do we stop that from happening? I am not at all sure we can. So I think it's meant to be a good read. I hope it's interesting. I hope it's educational, and I hope it's a warning.
Thank you. A lot of food for thought. A lot. And I have to say that the fact that NYU Press is behind it, it's a clear sign that it's going to be on the best-selling list.
Let's get it written first, and then I can say, the problem is finishing things. It's always a problem.
And I would like to meet again.
The ideas are great, but the execution, it's like the mathematical proof. You come up with I always think law review articles are like that, right? You come up with this great idea and then you have to prove it. And that's real work.
Yes, yes. But quite often we don't have big ideas. And unfortunately, politically speaking, our current leadership doesn't seem to have ideas. So just having ideas sometimes is really crucial. So thank you for the ideas. And I'm sure the execution will be flawless. We are moving along to question 7. How do you think its publication has affected your teaching and scholarship so far?
So they are not divisible. Teaching informs scholarship, scholarship informs teaching. Everything I'm writing about somehow makes its way into the classroom. It also it enriches my teaching because I think much more deeply about what I'm teaching than just, here's the rule, here's the facts, let's apply it and move on. My teaching, even though you don't always see it, really draws heavily on my work. Sometimes you see it, like I wrote a case book on scientific evidence. I don't know, 2005 was the first edition. We're in the 3rd edition. So that's a very visceral example of how it does. But I often have students writing problems. So for example, in expert evidence, there's things I come across in my research that I think are really hard to answer. Like last year, we wrote about this distinction in a motion in limine with a brief about experience-based expertise and whether it was lay opinion or expert. It's a really hard question, and courts get it wrong a lot. Courts disagree about it a lot. The standards are hard to understand. It was a very philosophically deep problem for the students to write about, and they did a great job, and they did a wonderful job, but they got a much richer problem to work on because of my research. If I hadn't been researching that for the treatise, I wouldn't have written about it. And so this year I'm thinking about a slightly related problem I want them to write about, which is about experts who testify about the meaning of rap lyrics and whether those should be admissible or not. I've lectured on this before about this sort of troubling, and people have written very good books on it. This is not my stuff, but about the dangerous use of these in trial. And I think it's very dangerous evidence to be used at trial. I think it's blurring the distinction between art and intent impermissibly. It's like putting Frank Sinatra in jail for drunk driving because he wrote "One More for My Baby" and "One More for the Road," right? There really is no difference. And so that's a broad brush to paint with, and some of the cases make better use of specific lyrics. But would we put Carrie Underwood in jail if somebody said she tore up her boyfriend's car? She has a song she sings about that. And I think there's such a racial piece to this that isn't being talked about enough, and the danger of sort of criminalizing an entire musical culture and using it against people, I think is really problematic. So that's going to find, because of that evidence that's coming into court, that's going to find its way into my class as well, and already has.
Thank you for articulating that particular idea. And when I thought about this question, I also included my belief that as a teacher, if you are in front of a group of students, what better way of legitimizing your expertise than published writing? So in addition to the fact that it helps the teacher become an expert in an area and develop a clearer view of the particular area they teach, I think it legitimizes the teacher for that spatial position in front of the classroom.
Yeah. You know, the death of expertise is something we've seen everywhere. There's a book about this, I think is really
Yes,
good from what people say. I have not read it, which I really should. But it's a problem, which is, why is the teacher not just another voice, right? Why is the professor, what does the professor bring that gives him authority in the classroom? And that's decades of knowledge and decades of work, you know, in the
exactly.
fields of that knowledge, not just, oh, I wrote an article once, right? Like I've spent 40 years thinking about expert evidence, or 30 years thinking about expert evidence, writing about it, doing treatises, writing articles, speaking about it. That should bring a heft to the teaching that I think is important.
Absolutely. I
I
am
mean, I don't try to
100%.
teach con law. I don't try to teach contracts. I couldn't, I mean, I could get there eventually, but you know, it's good to have fields of real expertise. I think that's so important.
I think so. And it's a pleasure talking to you, especially for the new classes of Duquesne Kline law students. They know that the Murray on contracts is from Duquesne. And if they didn't know, they are going to know that Moriarty on evidence is from Duquesne for now and for decades to come. So thank you. Moving along to question 8. We know what you're working on right now, but if you want to tell us, just pick one of them and further tell us a bit more, or we can move on to question 9. What would you like to work on next?
Oh, well, I think I talked about that too, what I'm going to
Yes.
work on next. So I think we've covered those. I know there was a question, and I may be getting ahead of myself, about what I would want to tell students.
Yes, that will be the last one. So
Yeah.
that will be the last question. So if you would like to talk a bit more about the connection between what you're working on now and what you would like to work on next, about that arc that connects your entire work and the philosophy behind it. I would love that, if possible.
So the arc of my work has been to explore the question of ground truth and how do we know when we're wrong in multiple ways. So I have written about the Salem witchcraft trials. I have written about battered women. I've written about the law of war as providing a template for how we look at self-defense and imminence, you know, the imminence problem of self-defense. I've written about the errors in forensic science repeatedly and how they lead to wrongful conviction and the need to get better at this. I and many people have been writing about this. And I think we have seen movement over the 20 years I've been writing about the errors in forensic science. I have also been writing about neuroscience as evidence, sometimes to educate, you know, simply explaining it, sometimes to talk about how it could be used to improve things like insanity defense cases. And also writing with this continued admonition that we are not there yet. This is all developing technology. It's too new in many ways to be used for the purposes for which we want to use it. I think what will be one of my probably final articles on neuroimaging evidence is my off-label neuroimaging, where I talk about how we use neuroimaging the way we use off-label drugs, which is very cavalierly often, without looking at the dangers, without looking at error rates, without looking whether there's any data to support what we're doing. And I think there's a lesson from the regulation of off-label pharmaceuticals that would be useful for courts trying to understand the importance of like consensus opinions on certain kinds of neuroimaging. And so those I think are important things to write about. And that's really what I'm sort of, that's going to finish the arc of my work in neuroscience. The arc of my work on forensic identification evidence and the shortcomings and its strengths will be in the chapter on co-authoring, and that would probably be my final piece on that. And then I have turned my attention in large part after my book to public health. and the role in getting it right. Once again, how do we know when we're wrong? You know, if you think back to I've followed the science very carefully during the pandemic. Some wonderful thinkers, writers, and scientists like Dr. Topol, Eric Topol, well-renowned leader of Scripps Institute, Peter Hotez, who invented the vaccine that he gave away to the world for free. And I followed them very carefully, and I think there's an essential humility to public health that we're really getting wrong about why have we gotten this so badly bungled and mangled so that people don't believe vaccines are good, that people don't believe masks actually save lives, that people don't care about filtering the air. Like, how did this all get so twisted up? And so public health messaging, I think, is important, and that's my next area that I'm heading off to. I am also a visiting scholar at Northeastern Law School Center for Health Policy and Law this year. And so some of my work on hysteria redux, is about gender, public policy messaging, and how do we know when we're wrong?
Thank you. And thank you so much for turning towards public health. Such an area of undeveloped area, in my view, because we are so far away from it. And it should not matter how much money we make on our paycheck to have access to this fundamental right.
Yeah.
So thank you.
My thought is, and I'm not alone, I'm taking this from other people who are aerosol scientists, but I think in about 20 years, we're going to wonder why we haven't installed things like HEPA filters everywhere. Why aren't we cleaning the air? Why are we willing to breathe virus-laden air, contaminant-laden air everywhere we go? We go to dinner and we're breathing tons of fumes from cooking. I mean, why are we willing to do this? Why haven't we cleaned the indoor air the way we clean the indoor water? And that's going to be a question we're going to shake our heads about and say, wow, we have the technology, we just weren't using it. Why is that?
Unfortunately, as someone who is deep believer in administrative state, I believe that is because we don't have a regulation.
Probably. Not yet.
Not yet, exactly. So finally, our 10th question, what would you like, Jane, to share with your students, current and future, as a final thought?
I spent a lot of time thinking about this, and I'm going to tell you, again, I'm going to quote Eliot, my favorite writer, and again, with the recognition that his actions and his words were troubling, they were often anti-Semitic, they were often racist, but the poetry lives on. And there is a big question about, can we separate poet from poetry? But I do. In this case, he started writing in the 1920s. He wrote his ground-shattering piece, The Wasteland, 21 years before he wrote his masterpiece, The Four Quartets. And he's got worldwide fame by the time he's in his 20s or 30s, early 30s, as probably the poet of a generation. And 21 years later, he spends years writing, which is why I take hope that my book will get finished. He spends years writing The Four Quartets, which is a masterpiece on every level. And in there, he writes, there's a poem, and I wrote it because even though I know most of it by heart, I don't want to get it wrong. He writes in East Coker, which is one of the poems in the Four Quartets, one of the four. He's in his mid-50s. He's already published one of the, quote, most famous works of literary modernism, The Wasteland, 21 years earlier. And he is still filled with doubt. And he says, so here I am in the middle way, having had 20 years largely wasted, the years of l'entre-deux-guerres, between two wars, trying to use words, and every attempt is a wholly new start and a different kind of failure, because one has only learned to get the better of words. For the thing one is no longer has to say, for the way in which one is no longer disposed to say it. And so each venture, each is a new beginning, a raid on the inarticulate, with shabby equipment always deteriorating in the general mess of imprecision of feeling. And I love that. I keep it, in fact, I have it up when I'm writing, because I want to remember that he was plagued with doubt, as many of us are as writers. I have all these what I call zombie articles sitting in a drawer somewhere, because I decided at some point they just weren't good enough, or they didn't have anything important to say. And I'm going to try to revive them and bring them back to life. But I think this is something real writers struggle with, which is it any good? Or is it just dross? I'm not sure how to say it. Is it crap? Right? That's the other word. And I see students doing that, and I tell them, aim to write poorly the first time. That you know how to do, that I know how to do, and all the rest is editing. And that's true. And that has kept me going for 30 years as a writer, which is just get the words on paper, the rest is editing. And so I hope students will remember that we all are simply trying to write better, all of us. We're no different than you are. We're just trying to write better. And it's a hard process, and you can do it.
Thank you so much, Jane. And thank you everyone for being here with us. And thank you. Thank you. You are an inspiration for us, for the future generations. And I hope to continue this exchange, and I look forward to reading your work, Jane.
Thank you so much, Dr. Neacsu. It was my honor to be here and my privilege, and I am so happy you've done this. It was a delight to do this today. So thank you so much, and goodbye.
Bye-bye.